Hey, what's going on here? What are you doing by this vehicle?
Picking up a document packet. What's the reason for the contact?
All right, let me see your ID.
Officer, state a clear reason why you need my ID.
Stop trying to lawyer me. Just do what I'm telling you.
This officer thought he was pressing just another citizen, but he picked the one man trained to turn sloppy stops into career-ending evidence. A black law professor who teaches constitutional litigation. Watch how one vague detention becomes a documented civil rights case because the professor didn't argue to feel right. He built a record that would hold up later. Officer Ryan Keller stood close and talked like the answer was already decided. He demanded ID. He told the man to stop recording. He ordered him to step away from his own car. Professor Malcolm Grant didn't raise his voice. He kept his phone up where it was obvious. He asked whether he was being detained or free to leave. Keller didn't give a straight answer. He kept the reason vague. He kept the command specific. Grant asked again. Same question. Calm tone. Clean words. He didn't chase Keller's accusations. He pinned Keller down on the only thing that mattered. And you could see Keller getting annoyed, because this wasn't going like his usual stops. No fear, no rambling, no begging, just a man calmly forcing an officer to put a legal basis on the record. Quick pause. Where are you watching from? Country or state, drop it in the comments. And if you like stories where people stay composed, know the rules, and make authority explain itself, hit like and subscribe. Now rewind, because this didn't start with yelling. It started with something small, the kind of stop that usually disappears, because most people just comply and try to get home. Grant had finished teaching for the day. He wasn't leaving a courtroom. He wasn't leaving a protest. He was leaving a normal workday. He stopped near a row of businesses to pick up a document packet he needed for the next morning. Keller was on patrol in that corridor. He'd been working that area long enough to think he could run a stop on instinct and clean it up later with the right wording. He saw Grant by his car and decided to make it a moment. Keller pulled in and approached fast. He didn't open with a question. He opened with control. He asked what Grant was doing there, then jumped straight to ID like Grant had already failed a test he didn't know he was taking. Grant answered basic and respectful. He explained why he was there. He didn't get defensive. Keller kept pushing anyway. He hinted at vague complaints. He hinted at vague descriptions. He floated suspicion without committing to a specific crime. Grant didn't argue the story. He focused on the status, detained or free to leave. And that's the split second where Keller made the choice that would come back on him. He didn't walk away. He didn't clarify. He tried to force compliance inside that gray zone where officers hope people don't know the difference. Grant lifted his phone and recorded openly. Keller saw the camera and his whole tone shifted. Keller didn't like the phone. You could tell by how fast he tried to make it the issue. He told Grant to put it away. He framed it like a safety problem. Then he framed it like a respect problem. Same move, different packaging. Grant kept recording. He didn't lecture. He didn't threaten. He just kept his words tight and repeatable. He asked if Keller was ordering him to stop recording. He asked again if he was being detained or free to leave. Keller dodged both. He pushed a third lane. He demanded ID, like it was a tax you pay for standing outside. Grant didn't say, "I don't have to," in a smug way. He separated the pieces the way a lawyer does when they want the record clean. He asked what specific crime Keller suspected. He asked what facts created reasonable suspicion. He asked if Keller was requesting ID or commanding it under a detention. Keller's answer kept sliding around. First, it was a vague, "We got a call." Then it became, "You matched the description." Then it switched to, "This is a high-issue area." He never anchored it to a clear offense. He never gave a specific suspect description either. He just kept trying to make Grant cooperate first so he could justify later. And here's the thing. Most people get trapped right there. They start defending themselves. They start explaining where they live, where they're going, why they're dressed a certain way, why they belong. They talk too much. They give an officer 10 things to twist into a report. Grant didn't do any of that. He gave only what was necessary. He stayed polite. Then he returned to the same legal checkpoints. Detained or free to leave. Reasonable suspicion or not. Consent or not. Keller tried to change the shape of the encounter. He ordered Grant to step away from the car. Not because Grant was reaching. Not because there was a threat. Keller wanted better positioning. He wanted control posture. He wanted Grant standing where it would look like a stop on camera instead of an officer cornering someone beside a vehicle. Grant moved slowly, slow enough that nobody could later claim sudden movement. He kept the phone steady. He made sure the street sign and the business entrance were in frame. Location, time. Witness potential. Keller demanded consent to search. He slid it in like a casual request, like it was normal, like saying no would be suspicious by itself. Grant said he didn't consent. Simple, no speech. Keller reacted like the refusal was the crime. His voice got sharper. He started talking about making this hard. He hinted that Grant could be held longer. That's the pressure tactic. Punish the person for knowing the boundary. Grant didn't react emotionally. He asked whether Keller was extending the stop because Grant refused consent. He asked whether Keller was threatening detention as retaliation for recording and asking questions. Keller snapped back with the kind of line officers use when they want to shut down accountability without saying the quiet part out loud. He told Grant to stop trying to lawyer him. He told him this wasn't a courtroom. Grant didn't take the bait. He kept it plain. He told Keller he was asking for the legal basis because that's what decides whether this was lawful or not. He didn't say it like a threat. He said it like a fact. Then Keller made the fatal mistake. He tried to turn the questions into interference. That's a common move. When they don't have the facts, they try to criminalize the person's mouth. They start treating speech like obstruction. Grant didn't argue the label. He asked one direct thing, whether Keller was ordering him to stop speaking and stop recording. He made Keller either admit it or back off. Keller didn't answer cleanly. Again, he pivoted. He looked around like he needed an audience. He started talking louder, hoping the environment would do the intimidation for him. He angled his body so Grant's phone would catch more uniform and less face. Small stuff, but it matters. Officers do it when they realize they're being documented. Grant adjusted his angle back. No drama, just keeping the record usable. And then Keller tried the oldest pressure tool on the street. He called for backup and said it out loud, like it was punishment. Grant didn't panic. He didn't move. He didn't argue. He did something smarter. He asked for Keller's badge number and name. Keller hesitated. That hesitation told you everything. Because now it wasn't just, I'm stopping a guy. Now it was, my identity is tied to this stop and he's preserving it. Grant repeated the request, calmly, like he'd done it 100 times. Keller finally gave it, but he gave it like it hurt, like it was a concession. Then Grant did the thing that flipped Keller's confidence into irritation. He identified himself. Not with swagger, not with a speech, just credentials, stated like a biography line in a court filing, name, profession. He taught constitutional litigation. He litigated civil rights cases. He dealt with unlawful stops. You could see Keller's posture change. Not fear exactly, more like recalculation. He realized the questions weren't random. They were structured to lock him into admissions. Every dodge would look worse later. Every shift in reasons would look intentional. Keller tried to regain control fast. He told Grant it didn't matter who he was. He said nobody was above an investigation. Grant didn't disagree. He didn't claim special treatment. He did the opposite. He made it about the same standard for everyone. He asked again, detained or free to leave? Keller still wouldn't answer. That's when the second unit pulled up. Sergeant Dana Pruitt stepped out, looked at Grant's phone, looked at Keller, then did what supervisors always do when they smell a mess. She tried to find the legal hook quickly so the department wouldn't pay for it later. She asked Keller what he had. Keller gave her the same vague language. Complaints, description, area issues, nothing clean, nothing specific. Grant didn't jump in. He didn't perform for the sergeant. He let Keller talk. He let the vagueness live on camera. Then Pruitt turned to Grant and asked what happened. Grant kept it short. He said Keller approached, demanded ID, refused to state a legal basis, and told him to stop recording. He said he'd asked multiple times if he was detained or free to leave and still hadn't gotten an answer. Pruitt looked back at Keller, and you could see the problem forming right there. Because now it wasn't just citizen versus officer. It was supervisor. Hearing an officer can't articulate reasonable suspicion while a phone records every second. Keller tried one last pivot. He tried to turn it into a voluntary contact. He tried to act like he was just checking on things, and Grant was overreacting. Grant didn't argue. He asked one more time, this time with Pruitt listening, whether he was free to leave. Pruitt answered, yes. Grant nodded. No celebration, no insult. He gave a calm, final line, more like a note than a victory lap. He said he'd be requesting the footage and the dispatch logs. Keller's face tightened, because he knew what that meant. Grant didn't leave like he'd won. He left like he'd just been handed a future exhibit and needed to protect it before anyone tried to blur the edges. He drove a couple blocks and parked somewhere lit with cameras. Not paranoia, basic discipline. He didn't want anyone saying he came back or kept it going. Then he did the unglamorous stuff that makes a case real. He saved the recording, twice. He checked the audio. He noted the exact time. He typed the location into his notes with business names and cross streets. He wrote down Keller's stated reasons in the exact order they changed. Not later, right then. Because memory turns soft. Reports don't. Next, he went back to the businesses on that strip. Not to argue. To preserve footage before it auto-deleted. He asked the print and ship place if their exterior cameras caught the sidewalk and curb. He asked who could pull video and how long the system kept it. He got the manager's email. He gave a tight time window and asked them to preserve it. Same with the coffee shop. Same with the storefront next door. Different angles matter. One camera catches distance. Another catches hand placement. Another catches where the patrol car sat. Then he looked for witnesses. Not a crowd. Just people who were stationary and could describe what happened without guessing. A delivery driver at the curb. A worker outside on break. Grant got names, numbers, and 2-sentence summaries of what they saw. He asked if either recorded. He didn't push if they didn't. That night he didn't post the video. No caption. No comments swore. He kept it quiet because he wanted clean process, not noise. Complaints, preservation, records, follow-up. The next morning, he drafted a written complaint like it was already part of litigation. He sent it to internal affairs at the police department, and he copied the department's public records unit. The complaint included date, time, location, both officer name and badge number, sergeant name if known, a numbered timeline of events, a clear statement that he recorded the full encounter, a specific list of records he was requesting. Then he added the part that changes everything inside a department, a preservation demand. He requested body-worn camera footage for all responding officers, dash camera footage if applicable, dispatch audio tied to that time window, CAD notes and call for service records. Any be on the lookout notice, suspect description, or bulletin Keller claimed existed. Supervisor communications if logged. He didn't write it like a rant. He wrote it like a checklist. He also sent a separate public records request with the same list and the same time window. He kept it narrow on purpose, so nobody could stall by calling it too broad. Then he sent a preservation notice to the city attorney's office. That's the email that makes people start asking each other uncomfortable questions, because now video going missing becomes its own liability. Within 2 days, Internal Affairs confirmed they received it. An investigator called him with the friendly tone departments use when they want to land a complaint softly. They framed it as a possible misunderstanding. A quick chat, a chance to clear things up. Grant didn't argue the tone. He asked one thing: whether the department was preserving all recordings, logs, and notes tied to the incident. He asked for confirmation in writing. The investigator paused, then said yes. Grant asked for the complaint or incident number. They gave it. That number mattered. It meant this wasn't a hallway conversation. It was in the system. A week later, Keller filed his report. And the report tried to do what the stop couldn't do in real time: create a legal basis after the fact. Keller wrote that he had a description. He wrote that Grant's behavior raised suspicion. He wrote it like Grant was the reason the encounter escalated. He sprinkled in vague safety language. He made it sound like a routine investigative contact that got difficult because the subject wouldn't comply. Grant didn't get mad, he got organized. He pulled up the video and compared Keller's report line by line against what Keller actually said on camera. He built a simple table: report claim on the left, timestamped contradiction on the right. No insults, no emotion, just conflicts. Then he submitted that comparison back to Internal Affairs as a supplement. That's where the stakes changed. Departments can sometimes defend a questionable stop with training language and legal spin. They can't easily defend a documented report contradiction once it's packaged cleanly with timestamps. That's how credibility collapses. After that, Grant started building the civil case the same way he taught it. Not for internet points, for court. He prepared a federal civil rights complaint under 42 U.S.C. Section 1983. Fourth Amendment for unlawful detention. First Amendment, if the evidence supported retaliation tied to recording or questioning. Equal protection only if he could prove selective enforcement, not just suspect it. He didn't throw in every claim just to sound aggressive. He built what he could prove. And that restraint made it worse for Keller because it signaled one thing: Grant wasn't performing. He was litigating. Once Grant sent that time-stamped contradiction chart to Internal Affairs, the whole situation stopped being a complaint and started being a department problem. Because now it wasn't just, did the officer make a bad stop? Now it was, did the officer write something that video doesn't support? That's the line that ruins careers. Inside the station, Keller tried to get ahead of it. He told coworkers it was nothing. He said Grant was one of those guys who records to stir things up. He acted like it was a social media nuisance. The problem was Grant hadn't treated it like content. He treated it like litigation. Internal Affairs pulled the body-worn camera footage. They pulled dispatch audio. They pulled the CAD notes. They checked whether there had actually been a call describing someone like Grant at that time. They checked whether Keller had typed anything into the system that would support his description claim. And this is where the department ran into the same wall Grant had already mapped out. Keller's justifications didn't line up. Even if you give an officer benefit of the doubt, a moving reason looks bad. A reason that shows up later in a report but didn't exist on camera looks worse. Internal Affairs interviewed Keller. Keller tried to explain it like a lot of officers do. He said it was totality of circumstances. He said it was behavior. He said it was intuition. He said he didn't remember every word, but the camera remembered. The investigator asked the questions that supervisors ask when they're trying to protect the department from paying out later. What crime did he suspect? What specific facts created reasonable suspicion? Why did he demand identification? Why did he focus on the phone? Why did he call for backup? Why did he never answer whether Grant was detained or free to leave? Keller gave long answers that didn't land on one clean legal basis. That's when they pulled Sergeant Pruitt into it. She didn't have to take a side emotionally. Her job was to explain what she saw and why she resolved it the way she did. She confirmed the key point without trying to be dramatic. Keller didn't give her a clear reason, and she ended it. That alone made Keller look exposed. A sergeant showing up and shutting it down tells everyone upstairs there wasn't much there. Then the city attorney's office got involved. Not because they cared about Keller's feelings, because Grant's preservation notice and Section 1983 intent forced the city to treat this like future litigation. That means risk assessment. That means exposure. That means asking whether the officer is now a liability witness. They did what city attorneys always do in these situations. They asked for the footage. They asked for the report. They asked for internal affairs notes. They asked if Keller had prior complaints. And that's when Keller's world got smaller. Even before any lawsuit finished, the department had to decide what to do with an officer whose credibility was now in question. Prosecutors hate credibility issues. Defense attorneys love them. Judges don't ignore them. If Keller's report didn't match video, every case he touched became a problem. The prosecutor's office flagged him, not with a public announcement, they didn't need to. It shows up quietly in how cases move. Fewer assignments, fewer courtroom appearances, supervisors keeping him away from anything that depends on clean testimony. Keller noticed. He complained. He said the department wasn't backing him. But this wasn't personal, it was math. A city can settle a single unlawful stop. A city can't survive an officer who becomes a standing credibility grenade. Grant filed the federal lawsuit under 42 U.S.C. Section 1983. He didn't write it like a dramatic story. He wrote it like a clean record. Unlawful detention without reasonable suspicion. A demand for identification without a stated legal basis. Pressure around recording and questioning, and the supervisor's arrival confirming the stop had no legs. Then discovery hit. That's the phase where officers realize they can't talk their way through it anymore. Grant requested all recordings and retention logs. Training materials on stops, recording, and detentions. Keller's disciplinary history, if relevant and discoverable. Any policy about when ID can be demanded. Any supervisor reviews tied to the incident. And because Grant knew how cities defend these cases, he anticipated the move. The city would try to say it was a consensual encounter. They'd try to say Keller was just checking. They'd try to say Grant could have left at any time. Grant's evidence boxed that argument in. Keller had used commands. He had demanded compliance. He had called backup. He had tried to control movement. He had pushed the phone issue. The whole vibe read like detention, not a casual chat. The city started settlement conversations early, not because they suddenly became moral, because litigation is expensive and unpredictable, and the risk wasn't just paying Grant. The risk was what a judge might say about the department's practices. The risk was what discovery might reveal about training and supervision. Internal Affairs finished their review. They sustained key policy violations. Again, departments sometimes soften this stuff. But where video exists, they can't fully escape it. They pointed to improper escalation, poor articulation of legal basis, failure to properly manage a recorded encounter, report accuracy issues. That last one hurt most. Report accuracy issues aren't oops, they follow you. Keller got disciplined first, then reassigned, then pulled off proactive work. Then it moved toward termination once the department realized his credibility issues would keep spreading into every case file he touched. He tried to fight it through the union. He claimed he was being targeted. He claimed the professor was using influence. That didn't work because the department didn't need influence to see the problem. They had the footage. They had the report. They had the contradictions. Keller lost his job. Depending on the state, decertification became a risk too. Even when decertification doesn't happen fast, departments talk. Hiring managers ask. Background investigators dig. A sustained finding tied to dishonesty or major policy violation can make an officer radioactive. Grant's case resolved without a drawn-out trial. The city settled. The settlement wasn't just money. It included policy review commitments, training updates, and stronger documentation requirements for stops and recording encounters. The city didn't advertise it as, "We were wrong." Cities rarely do. But changes show up in what officers are told to do afterward. Clear articulation, clear release, less gray zone. Grant didn't do a victory tour. He went back to teaching. He used the experience the same way he used everything else, as a real example of how the system actually responds when someone keeps their composure and builds the record correctly. And Keller, he didn't get canceled. He got consequences. The kind that come from turning a badge into a shortcut and forgetting that cameras don't forget and paperwork can't outmuscle video forever. That's the real lesson here. You don't beat power by getting louder. You beat it by staying controlled, asking the right questions, recording lawfully, and making the system answer with receipts. So let me ask you, if you were in Grant's position, would you have stayed that calm? Would you have kept your words tight? Or would the pressure have pulled you into a fight that helps the officer later? Drop your take in the comments and share this story with someone who needs it. And don't forget to subscribe for more real stories like this. Calm, documented, and consequence-heavy.
Hey, what's your name? Let me see your ID.
Sir, what's the reason you need it?
We got a call, and it seems like you may be a suspect, so just show me ID.
I did nothing wrong. This is nonsense.
Let's step outside and talk. Come on.
No. If I'm not detained, I'm staying right here.
Let's go. Outside. Now.
Don't put your hands on me.
What happens when a cop demands ID from a calm black customer in a cafe, can't name a crime, and still goes hands-on because the guy keeps asking basic legal questions? The answer isn't what people expect because the cameras didn't just capture a bad stop. They captured conduct that later got torn apart in federal court. Where are you watching from? City and state? Drop it in the comments. And if you like stories where receipts beat excuses, hit like and subscribe. Juniper and Slate in Riverside Heights was in weekday mode. Coffee line, laptops, quiet conversations. Officer Tyler Wainwright walked in and immediately targeted Derek Lawson near the front area. He demanded Derek's ID. Derek didn't argue, he didn't posture. He asked two things, calmly: whether he was being detained and what the legal reason was. Wainwright didn't give a clear answer. He repeated the ID demand. Then he tried to move Derek out of the building, telling him to step outside. Derek stayed put and asked the same questions again. Detained or not? What lawful basis? Wainwright's tone tightened. He kept pushing for Derek to move. Out the door, away from the counter, away from the crowd. The problem was, Juniper and Slate had cameras, multiple angles, entry, register, seating area. Maya Rios, the cafe manager, stepped in. She told Wainwright's staff hadn't called police. She told him Derek was a customer. She told him the business wasn't trespassing him. Wainwright brushed her off. He acted like her words didn't matter. That mattered later, because it killed the most common excuse. The business wanted him removed. Wainwright escalated anyway. He closed distance. He blocked Derek's path. He demanded ID again. He tried to force Derek outside again. Still no clear crime stated. Customers started recording on phones, not loudly, just steadily. People knew what this was turning into. Then Wainwright put hands on Derek and tried to steer him toward the door. Derek didn't swing, didn't shove, didn't give Wainwright the reaction he could label resistance. He kept controlled, kept asking the same questions, kept his hands visible. That's the chess move Derek made without announcing it. No chaos to rewrite later. A supervisor got called. Sergeant Elena Park arrived, took in the room, and asked Wainwright for the lawful basis. Wainwright tried to justify it with vague language. Suspicious person, noncompliance, ID refusal. Park looked at the facts in front of her. The manager wasn't trespassing Derek. Nobody at the cafe had called. No specific crime. So Park chose the cleanest option. She ended it. She disengaged. No arrest, no forced removal. Wainwright wasn't happy, but he had to back off. Most people would have treated that as the end. Derek treated it as step one, because he knew the next danger wasn't in the cafe. It was on paper. He immediately asked Maya about the security footage, how long it's stored, who controlled it, how to preserve it. He also started a timeline in his notes while details were fresh. Time of entry, the ID demand, the attempt to force him outside, the manager's statement, the hands-on moment, the supervisor's arrival. He wasn't chasing attention. He was locking down evidence before anyone could lose it. Derek didn't treat Sergeant Park ending the stop like a victory. He treated it like a closing window, because he knew what usually happens when an officer realizes they pushed too far in public. They retreat in the moment, then rebuild the story later in a report. So Derek stayed at Juniper and Slate and handled it like evidence. He didn't wander around asking people what they thought. He went straight to Maya Rios, the manager, while staff and customers were still in the room and the scene was still fresh. He asked where the cameras were positioned and whether the system recorded continuously or only on motion. He asked how long the footage stayed in the system before it overwrote. He asked whether the recording saved locally to the cloud or both, and who had the login and the authority to export it. Maya didn't hesitate. She told him staff hadn't called the police. She also made it clear the cafe wasn't asking for Derek to be removed and wasn't claiming he was trespassing. That point mattered because it cut off the most common excuse officers used later: the business requested removal. Derek asked Maya to preserve the entire segment, not a trimmed clip. He wanted the minutes before Wainwright entered, the full interaction, and the minutes after Park arrived and ended it. He asked her to preserve it from every camera angle that caught any part of the encounter, including the entry area, the counter line, and any wide shot that showed positioning and movement. He specifically asked for a copy exported with the date-time overlay, visible if the system supported it, because he didn't want anyone arguing later that the timing was unclear. He also asked her to keep the original file in the system untouched, because exported copies are useful, but originals are harder to challenge. Maya agreed and took it seriously. She pulled up the system and started identifying the relevant cameras. One of the staff members who had access helped too. Derek watched without hovering. He just made sure they were pulling the right time window and not missing an angle. While they worked on that, Derek opened his phone and started writing a timeline. He didn't write a diary entry. He wrote a sequence. He noted the approximate time he entered the cafe and where he stood. He noted when Wainwright walked in and how quickly he targeted him. He wrote down when the first ID demand happened and when Wainwright tried to force him outside. He wrote down that he repeatedly asked whether he was being detained and what the legal basis was, and that Wainwright did not clearly state a crime. He noted when Maya stepped in and said staff hadn't called police, and the cafe wasn't asking for Derek to be removed. He noted Wainwright dismissing her and continuing. He wrote down the moment Wainwright went hands-on and tried to steer him toward the door. He noted that he kept his hands visible and did not strike or shove. He wrote when Sergeant Park arrived, asked for the basis, and ended the stop. He also wrote down what witnesses were doing, because that becomes important later. He noted which customers had phones out, where they were standing, and the angles they likely captured. Not because he wanted them involved in drama, because he knew witness video fills gaps when Bodycam gets blocked, turned off, or pointed away. Once he had the cafe side preserved, Derek moved to the government side. He didn't wait a week. He didn't wait until he felt calmer. He treated the first 24 hours as the only time he could control whether records got cycled out under routine retention. He drafted preservation requests directed to the police department and the city. He requested the body-worn camera footage from Officer Wainwright and Sergeant Park, plus any in-car camera footage if the unit had it. He requested dispatch audio the CAD log, and any call notes associated with the event. He requested the incident number if one existed, and if it didn't, he requested the timestamps and unit identifiers used to locate it. He asked for any supervisor communications tied to the response and any evidence handling logs showing when video was accessed, copied, or reviewed. He also asked for something people forget: confirmation in writing that a hold was placed on those records. Derek wasn't going to accept, "We'll look into it." He wanted an acknowledgement that the city understood it had a duty to preserve. Then he filed his complaint quickly. He didn't write it like a rant. He wrote it like a record. He described the stop, the lack of a stated legal basis, the manager's statement that the business hadn't called and wasn't removing him, the hands-on escalation, and the supervisor's decision to disengage. He included that there were multiple independent recordings, including cafe security footage and witness phone video, and that he had already requested preservation of Bodycam and dispatch records. That's what changed the posture of the entire situation. Derek didn't just say, "This happened." He said, "This happened, and these systems recorded it." A few days later, Derek saw why he'd moved fast. Wainwright's written report started circulating through the normal channels, and it didn't match the reality witnesses saw. The report leaned on vague labels like "suspicious person" and treated Derek's refusal to provide ID like that alone justified escalation. It framed Derek's calm questions as non-compliance, the kind of wording that makes a stop sound lawful, even when the officer never stated a clear crime. The report also suggested the officer had a business-related basis, the kind of implication that makes it sound like the cafe wanted Derek removed. That was a problem for Wainwright, because Derek already had the manager on record saying staff hadn't called police and the cafe wasn't asking for Derek to be removed. And that statement wasn't private. It was made in public, in front of witnesses, inside a building covered by cameras. Then Derek noticed something that pushed this beyond a standard complaint. The report didn't just seem wrong. It seemed like it was being shaped. Details tightened in a way that didn't feel like correcting a typo. Language shifted toward justification. The report started reading less like an officer writing what happened and more like an officer building a legal defense for what he did. Derek couldn't prove the exact moment it changed from the outside, but the pattern was obvious enough to raise a serious allegation that the narrative was being revised after the department realized recordings existed. At that point, Derek stopped thinking like a complainant and started thinking like a case file. He organized his timeline so it matched likely record timestamps. He listed every evidence source that could be subpoenaed or requested. He identified the key contradiction that couldn't be explained away. The officer implied a business-based removal, while the manager clearly said the opposite. He flagged that the stop lacked an articulated lawful basis, and that the report's framing conflicted with recorded reality. He didn't need to speculate about motives. He didn't need to argue online. He just needed the mismatch on the record. Because once the issue becomes video versus report, departments can't bury it the same way. That's when internal affairs has to pull footage. That's when supervisors have to explain why an officer ignored the manager. That's when evidence handling becomes relevant. And that's when outside scrutiny becomes possible. Derek understood that. He built the foundation before anyone else could rearrange the facts. Derek didn't have to beg anyone to take it seriously. The mismatch did that for him. Once his complaint landed with a timeline, preserved cafe footage, and pending records requests for Bodycam and dispatch, the department couldn't treat it like a "he said, she said." They had to pull the recordings. If they ignored it and the video surfaced later, it would look like a cover-up. Departments hate that risk more than they hate a complaint. Internal Affairs opened a review. They pulled the CAD entry that supposedly brought Wainwright to Juniper and Slate. They pulled dispatch audio. They pulled Wainwright's Bodycam and Park's Bodycam. They asked for the cafe footage through formal channels too, because they needed their own copy with documented chain of custody. And that's when things started breaking. The dispatch trail didn't match the energy Wainwright brought into the cafe. There wasn't some clear call from staff saying a customer was threatening people. No request from the manager to remove Derek. The "why are you here" part stayed vague, which meant Wainwright's report had to do extra work to justify what his body cam showed. Then the video comparisons started. Cafe footage showed the officer entering and locking onto Derek without doing basic fact-checking with staff. It showed Maya stepping in and saying staff hadn't called police, and the cafe wasn't asking Derek to leave. It showed Wainwright brushing past that and continuing anyway. It showed the physical contact happening without Derek attacking or lunging. It showed witnesses filming. Bodycam added something else: tone, proximity, and the way Wainwright kept trying to move the interaction outside. That's a pattern investigators recognize. Fewer cameras, fewer witnesses, more control. Park's body cam mattered too. It captured the moment a supervisor asked for the legal basis and didn't get a clean answer. It captured Park choosing to end it instead of escalating it into an arrest that would have looked worse on review. Now, the report. Investigators compared Wainwright's written justification to the recordings, and they kept finding gaps. The report leaned hard on vague terms that sound official, but don't actually explain lawful grounds. Suspicious, refused to identify, non-compliant. That language gets used when an officer needs the reader to assume there was danger without describing a real crime. Then came the bigger problem: the report history. Departments track edits, sometimes loosely, sometimes clearly. Investigators saw signs the narrative changed after the recordings were requested or reviewed. The timing was bad. The phrasing got tighter in the direction of legal justification. That raised a specific allegation. Wainwright didn't just write a questionable report. He may have tried to retrofit the facts to match what he'd already done on camera. That's when it stopped being only about Derek. Because if one officer is willing to adjust reports after video exists, you don't just review the stop, you check patterns. Internal Affairs pulled other incidents tied to Wainwright in the same unit. They started with stops that had similar language in reports. Same phrases, same structure, same refused to provide ID framing, same claims about businesses requesting removal. They cross-checked those with whatever recordings still existed: body cam, store cameras, dash cam, jail intake video, even 911 audio. They found enough inconsistencies that supervisors couldn't pretend it was isolated. At that point, the city attorney's office got involved. Not because they cared about Derek's feelings, because liability was now obvious. A recorded stop with no stated lawful basis, followed by a report that doesn't match video, followed by signs of revision, turns into expensive civil exposure fast. Then it reached the level department's fear, outside eyes. The case got referred for civil rights review. When federal investigators look at a stop like this, they don't only ask, was this bad? They ask, was this part of a pattern? They ask about training, supervision, discipline history, and whether supervisors ignored warning signs. They ask whether evidence was mishandled or altered. They ask whether prosecutors relied on those reports in court. That last part triggered a chain reaction. If Wainwright's reports were unreliable, cases he touched became questionable. The city and department started flagging arrests and stops tied to him and his unit. Some defense attorneys filed motions. Some prosecutors quietly reviewed files. Some old cases got reopened because the credibility issue wasn't hypothetical anymore. It was documented. Wainwright got pulled off the street during the investigation. Administrative leave at first, then tighter restrictions. No public contact, no discretionary stops. The department started separating him from situations where he could create more evidence problems, and Derek kept doing what he'd done from the start, keeping it clean. He responded to requests. He provided copies of what he had. He didn't exaggerate. He didn't add new claims. He stayed inside the record. That discipline made him hard to discredit, which is exactly what Wainwright needed to do to survive. As the investigation expanded, more people came forward. Not because Derek went viral, because the department started asking questions and people started realizing someone was finally taking the complaints seriously. Witnesses from other stops described similar pressure tactics: demands without clear reasons, threats framed as orders, and reports that didn't match what happened. By the time the review reached its late stage, Wainwright wasn't facing a routine discipline meeting. He was facing a credibility collapse. And that's the difference between a local complaint and a federal case. A local complaint argues about behavior. A federal case argues about rights, records, and truthfulness under color of law. By the time outside investigators got involved, Wainwright's problem wasn't a complaint. It was that the record didn't support him, and the record kept getting bigger. Internal Affairs finished its review first. They didn't have room to play neutral. Cafe cameras showed Wainwright pushing the stop without a clear legal basis. Witness video backed it up. Park's Bodycam showed a supervisor asking for lawful grounds and not getting a clean answer. The manager's statements undercut the business wanted removal angle. Then the report issued turned it into something more serious. Investigators focused on when the report was written, what it originally claimed, and how it changed after the department knew recordings existed. They pulled system logs. They pulled revision history where it existed. They interviewed people who handled the file. They compared the report language to what the videos actually showed. That's where Wainwright's situation collapsed. The report didn't just sound off. It looked designed to justify actions after the fact. That's not a style problem. That's a truth problem. The department terminated him, not because they suddenly grew a conscience, because they could see what was coming. If they kept him, every case he touched would become a credibility fight, and every future stop would risk another recorded failure. But termination didn't close it, it opened it. Federal civil rights scrutiny moved in hard once the evidence handling and report accuracy issues came into view. Investigators didn't treat the cafe incident like a one-off. They treated it like a window into how Wainwright operated and how his unit was supervised. They pulled other stops tied to him. They looked for the same patterns: vague, suspicious person framing, Idaho demands, without clear lawful grounds, escalation when someone asked basic questions, and reports that leaned on stock phrases instead of specific facts. They checked Bodycam when it existed. They requested third-party video when it didn't. They reviewed whether prosecutors had relied on Wainwright's reports to win charges. That triggered reopened cases. Some were reviewed quietly. Some got challenged directly. Any case where Wainwright's word was the backbone became a problem, because credibility is the backbone of policing. Once that breaks, it breaks everywhere. The city tried damage control. They started negotiating. They reviewed policy. They pushed training language. They tried to frame it as one bad officer, except the investigation kept pulling at the supervision thread. Who approved his reports? Who ignored earlier complaints? Who kept putting him on the street, doing the same kind of stops? Derek stayed consistent through all of it. He didn't do TV interviews every week. He didn't turn it into a personal brand. He kept responding to official requests, kept his timeline consistent, and kept his focus on records: video, dispatch, Bodycam, logs. That approach made him hard to attack. No exaggerations to pick apart. No contradictions to exploit. When the federal criminal case landed, it wasn't built on outrage. It was built on documentation. Prosecutors laid out the sequence. Wainwright escalated a stop without lawful grounds, ignored the manager who contradicted the supposed reason for police involvement, and went hands-on while cameras recorded it. Then he generated a report that didn't match what the recording showed. Then the report appeared to be revised in ways that moved it toward justification after the fact. That combination matters in federal court. It turns into questions about deprivation of rights under color of law and falsification tied to official proceedings. It turns into evidence integrity. It turns into whether someone used a badge to do something unlawful and then tried to cover it with paperwork. Wainwright tried to defend it the usual ways. He tried to frame Derek as uncooperative. He tried to make the ID issue sound like a threat. He tried to lean on officer discretion. None of that works when the video shows calm questions and no stated crime, and when the manager's statements and dispatch trail don't support the officer's narrative. In the end, the federal prosecution didn't need dramatics. It didn't need a viral mob. It had what courts respect: multiple camera angles, body cam, dispatch records, and a clear conflict between recorded reality and an officer's written story. Wainwright was convicted and received a 15-year federal prison sentence. After that, the fallout widened. The city paid. The department faced oversight pressure. The unit's prior work stayed under a cloud. Supervisors had to answer for what they missed or tolerated. Training got rewritten in the ways cities always rewrite training after a lawsuit: clearer documentation rules, stricter body cam compliance, tighter standards on suspicious person calls, and more explicit discipline for report falsification and evidence mishandling. Derek didn't come out of it happy. He came out validated. That's different. He got what most people don't get in these situations: an official record that matched what happened. And that's the takeaway. Derek didn't win by being louder. He won by being precise. He stayed calm, asked the right questions, didn't give the officer an excuse to claim resistance, and immediately treated it like an evidence problem. So let me ask you, if you were in that cafe, would you have recorded? Would you have stepped in like Maya did? Would you have done what Derek did and locked down the footage the same day? Drop your thoughts in the comments and share this with someone who thinks paperwork doesn't matter. It does. And if you want more stories where accountability comes from facts, records, and real consequences, like and subscribe so you don't miss the next one.
All right, what are you doing back here? Who are you waiting on?
Waiting on a driver? What's the reason for the contact?
Loitering back here taking notes. This area's had problems.
Understood. I'm federal law enforcement, on duty. I can be verified through dispatch or supervisor.
Don't lie, man. You don't look like federal. I don't want to play games. You're under arrest.
Hey, hold on.
What happens when a local cop decides a calm black man doesn't look like a federal agent and keeps escalating even after the guy says he's Secret Service? The answer gets ugly fast because the body cam didn't just catch a bad attitude. It caught misconduct in real time. Drop a comment and tell me where you're watching from, state or country. And if you're here for stories where power trips backfire and accountability actually shows up, hit like and subscribe. These are the ones that need daylight. All right? Here's what went down. It started mid-conflict behind a shopping plaza, near the service lane between a pharmacy and a coffee spot. Early evening. People coming and going. Cameras on every corner. A couple cars idling at the curb. The kind of place officers love because they can check things out and feel in control. Officer Ryan Kessler had Malik Carter pinned in that invisible box cops use when they want compliance without saying the word: close distance, squared shoulders, one hand hovering near his belt, the other gesturing like it was directing traffic. Kessler kept issuing commands. Turn around, hands visible, don't reach for anything. Malik didn't match his energy. He stayed still, he spoke slow, he kept his hands away from his pockets. And Kessler hated that. Because Malik wasn't acting scared, he wasn't babbling, he wasn't begging to be let go. He was just steady, professional. The exact thing a power-tripping officer reads as attitude. Kessler demanded to know what Malik was doing back there. Malik gave a simple answer through his calm tone and minimal movement. He was waiting on a driver, and he wasn't doing anything illegal. That should have been the end. It wasn't. Kessler started building a story out loud. Suspicious person, loitering, possible trespass. Then he tried the classic trap. Rapid-fire questions meant to trip you up. Where do you live? Why are you here? What's in your bag? What's in the vehicle? Who are you meeting? You could hear the shift. It wasn't about safety, it was about dominance. Malik didn't argue the way people think arguing looks. No shouting, no insults. He just held a boundary. He asked plainly what Malik was being detained for. He asked if he was free to leave. He said he could identify himself, but he wasn't consenting to searches, and he wasn't going to do random hood-of-the-car theater without a reason. That made Kessler's voice jump up another level. Kessler stepped closer, too close. Malik took one small step back, not dramatic, just enough to keep space. Kessler interpreted that as defiance. He angled his body like he was preparing to grab Malik. This is the part people miss when they watch clips online. The escalation usually isn't one big moment. It's tiny choices stacked on the top of each other. Distance, tone, threats disguised as orders. That's how a routine interaction turns into a confrontation. Now, rewind. Malik Carter wasn't out there looking for trouble. He'd spent most of that day in suit and tie mode, rotating between protective work planning and coordination calls. He was in town on an advanced detail, not some fantasy spy mission. Real work, timing, routes, access points. He'd stepped away from his team for a few minutes to meet a contracted driver in the plaza. The driver got delayed. Malik waited where he could see the pickup area and keep situational awareness. Standard. He also didn't broadcast what he did for a living. Agents don't do that. He wore plainclothes, neutral jacket, clean haircut, no big logos, no tactical cosplay. Just a guy who looked like he belonged anywhere. Which is exactly why Kessler decided he didn't belong there. Kessler had been patrolling that district like he owned it. He had been with the department long enough to be comfortable. Too comfortable. He liked being the guy who handled things. He also had a pattern. Stop first, justify later. People around town knew it. They didn't always say it out loud. They just avoided him. That evening, he rolled into the plaza on a slow loop. He spotted Malik standing near the service lane. Black man, alone. Hands calm, not frantic, not acting guilty, just waiting. Kessler read that as a challenge. You could practically see it in how he parked. Not a normal pull-up. He cut the angle to block space. Quick stop, door open fast. That posture cops use when they want you to feel the weight of the uniform before they even speak. He approached Malik and started with suspicion, not greeting. Not, hey, you okay? Not, everything all right? It was straight into control mode. Malik responded the way trained professionals respond. He stayed polite. He didn't mirror hostility. He gave only what he needed to give. He kept his hands visible. He didn't reach for anything. Kessler kept pushing. Malik tried to end it clean. He said he was federal law enforcement and he was on duty. He said he could show credentials. He didn't do it fast. He didn't do it flashy. He did it the safe way. Slow movements, clear communication, hands staying where Kessler could see them. That's when the power chess game got real. Because Kessler didn't want Malik to be federal. He wanted Malik to be a suspicious guy so he could win the interaction. He wanted the story to end with compliance. Maybe a search, maybe a lecture, maybe cuffs for officer safety. The usual. Malik's federal status ruined that script. So Kessler tried to call it a bluff. He accused Malik of lying without using the exact word. He implied impersonation. He said people carried fake badges. He said he'd seen it before. He demanded Malik hand over whatever ID he had and kept saying he'd decide what was real. Here's the thing. Secret Service credentials aren't a library card. You don't just toss them to an agitated officer who's already escalating. Agents are trained on how to present identification safely. Malik followed that. He told Kessler where the credentials were. He asked if Kessler wanted him to retrieve them slowly. He kept his hands open and visible. All method. Meanwhile, the environment changed. A nurse in scrubs walked out of the pharmacy and slowed down. A delivery driver stopped near the curb and watched. The store manager hovered near the entrance, pretending to straighten a display, but his eyes stayed locked on the scene. Phones came out. Quietly. Not dramatic. Just reality in 2026. People don't trust it'll be handled internally anymore. They record first. Kessler noticed the phones. That should have made him chill out. Instead, it made him double down. Some officers treat witnesses like threats. Malik finally produced the badge and credentials. Not thrust forward, not waved around. Presented in a controlled way so Kessler could read it without Malik stepping into his space. And for half a second, Kessler froze. His face did that quick recalculation people do when they realize they might have messed up. It wasn't remorse, it was risk assessment. Then he made the worst possible choice. He rejected it. He dismissed it like it was a fake. He talked over it. He acted like he'd caught Malik trying something. He said he was going to detain Malik until he could verify it. And he said it like Malik was some criminal who'd been caught mid-scam. That's the mask-off moment right there. Because verification is normal. The way Kessler handled it wasn't. He wasn't trying to confirm identity. He was trying to punish Malik for not folding. Malik didn't raise his voice. He didn't get baited. He didn't give Kessler anything to twist into resisting. He just stated clearly that he was a federal agent, that Kessler needed a supervisor, and that the situation was being recorded. Kessler's jaw tightened again. He looked around at the phones. He looked back at Malik. Then he reached for his radio. And that's when the chain reaction started. Dispatch, supervisors, and a level of oversight Kessler couldn't control. Kessler hit his radio and started talking like he was already writing the report in his head. He told dispatch he had a male subject claiming to be federal law enforcement. He said he needed verification. He left out the part where he'd escalated first. He left out the part where Malik had offered credentials calmly. He left out the crowd and the phones. Malik stayed in place, hands visible, body angled slightly away from Kessler's reach. That's not attitude, that's survival math. Kessler tried to regain control with volume and pace. He moved in tighter again, like he wanted to box Malik against the curb. He kept demanding Malik hand over the badge. Malik didn't comply with that part. He kept the credentials positioned where Kessler could read them without taking them. Smart, safe, standard. Kessler didn't like it. So he went for the threat that usually works on normal civilians. Detainment for officer safety. He said Malik was going in cuffs until everything checked out. That's when Malik forced the moment into the light. He didn't bark, he didn't plead. He stated the consequences. He said Kessler was about to unlawfully detain a federal agent on duty. He said this would trigger notifications. He said he was requesting Kessler's supervisor immediately. He also said the entire interaction was on Bodycam and being recorded by witnesses. That last part mattered. You could feel it. Kessler glanced at the bystanders again. 2 phones were clearly up now, one held low, one held chest high. A third person had stopped near the coffee spot door with their camera pointed straight at the service lane. Kessler's eyes did the quick scan officers do when their confidence meets a liability. Then he tried a different tactic, the humiliation angle. He asked Malik if he even knew what Secret Service did. He implied Malik was impersonating and would be charged. He said he could make this easy if Malik just complied and stopped playing games. Malik didn't bite. He repeated the same points, clean and boring. Federal law enforcement on duty, credentials presented. Supervisor requested. No consent to searches, no sudden movements. And now, dispatch was responding. Dispatch asked Kessler for details. Badge number, agency, name. Kessler gave Malik's name, but you could tell he didn't want to. He sounded irritated, saying it out loud like it tasted wrong. Dispatch asked him to spell it. He snapped the letters off fast. Then dispatch asked the question that started pulling the rug out from under him. Did the subject provide credentials? Kessler hesitated. He answered in a way that tried to keep control of the narrative. He said yes, but he couldn't confirm authenticity. He said he was maintaining officer safety. He said he needed a supervisor on scene. Dispatch acknowledged, and then said they were contacting a sergeant. That's the first domino. Because once a sergeant hears possible federal credentials, the game changes. It's not optional. The department doesn't want a lawsuit. They don't want a federal complaint. They don't want a call from DC asking why their patrol officers cuffing a Secret Service agent behind a pharmacy. And Malik knew that. He didn't say it like a threat. He said it like a fact. Kessler tried to keep Malik frozen in place while he waited. He positioned himself like a gate. He watched Malik's hands like Malik was the problem. He asked again where Malik's vehicle was. He asked again who Malik was really meeting. He kept fishing for something he could justify on paper. Malik stayed tight. He gave nothing extra. Then the sergeant arrived. Sergeant Elena Park pulled in fast but not reckless. She didn't rush up yelling. She walked in, took a 3-second look at Kessler's posture, Malik's posture, and the crowd. She saw it immediately. She saw who was escalating. Kessler started talking the moment she stepped in. He tried to frame it like Malik was the one being difficult. He said Malik refused orders. He said Malik was argumentative. He said Malik was not cooperating. Park didn't accept the story at face value. She asked the simplest question in the world. What was the original reason for contact? Kessler gave a weak answer. Suspicious person. Loitering. Service lane. Could be casing. Park looked around, cameras on the building, people recording. A normal public plaza, no posted, no trespassing signs in sight. Then she looked at Malik. She didn't ask him to perform respect. She asked for clarity. Malik presented credentials again, the same careful way. Park didn't snatch them. She read them. Her face changed. Not panic, not worship. Just that professional recognition of a situation that can cost the department money and careers if mishandled. Park asked Malik if he was on duty. Malik confirmed. Park asked Kessler if he had demanded Malik's badge be handed over. Kessler tried to talk around it. Park cut through it and told him to step back. That moment right there, that's when Kessler lost the room. Because now it wasn't Kessler versus Malik. It was Kessler versus reality. And reality had witnesses. Park got on her own radio and requested dispatch verify credentials through proper channels. She also asked for a lieutenant to be notified, because she wasn't about to carry this alone. Kessler stood off to the side, jaw tight, watching Park talk like he'd been betrayed. Then dispatch came back with the confirmation pathway. They didn't confirm everything over open air for obvious reasons. They confirmed enough. They indicated the agency contact line. They indicated the supervisor contact. Park nodded, got the number, and made the call. That call changed Kessler's body language more than anything else, because now it wasn't maybe. Now it was official process. While Park made the call, Kessler tried to start undoing the last 10 minutes with excuses. He said Malik's behavior raised red flags. He said he had to check. He said people impersonate officers. He said he was just doing his job. He tried to make it sound responsible. It didn't land. Because everybody watching had seen the tone, the posture, the threats. They'd seen Kessler reject credentials. They'd seen him escalate when Malik stayed calm. They'd seen him get louder when phones came out. And Park had seen the same thing with a badge in her hand. Then the other agencies showed up. Without even showing up, Park got off the phone and her tone shifted. More formal, more careful. She told Malik calmly that his supervisor had been notified and was aware of the location. She told him they were going to conclude the contact immediately. Then she turned to Kessler and told him to stop speaking and to deactivate his ego before he made it worse. Kessler didn't listen. He couldn't help himself. He asked Malik, loud enough for the bystanders to hear, why Malik didn't just say he was Secret Service from the start. That was wild, because Malik had said it early. Kessler just didn't believe him. Malik didn't clap back. He didn't lecture. He gave one clean response through the narrator's reporting. He had identified himself, he had offered credentials, and Kessler had chosen escalation anyway. Park told Kessler to get in his car. Kessler started to protest. Park didn't argue. She gave him a direct order. He finally moved, stiff and angry, and walked toward his cruiser like someone walking away from a fight they thought they were winning. Park then spoke with Malik briefly, professional to professional. She asked if Malik wanted medical attention, if he felt threatened, if he wanted a formal complaint initiated on scene. Malik didn't make it dramatic. He requested the Bodycam and Plaza camera footage be preserved. He requested witness info be collected. He requested the incident be documented as a federal contact gone wrong. Park agreed, because she had no choice. And just like that, Kessler's routine stop turned into an evidence event. The bystanders didn't disperse right away. A couple people stayed to offer their names and numbers. One guy said he had the entire escalation on video from the first command. The store manager said the exterior cameras covered the service lane and the curb. Park collected what she could and told them the department would follow up. She knew, though. The videos were already leaving the scene. Because that's how it works now. A clip doesn't need the department's permission to go public. Malik left the plaza the same way he'd stood there, controlled, minimal, not giving anyone a reason to twist the narrative. Kessler sat in his cruiser, staring forward, trying to look like a man still in control. But the control was gone, because the Secret Service supervisor had the sergeant's number. The department lieutenant had been notified. Dispatch logs existed, body cam existed, witness video existed, all the receipts. By the next morning, Kessler's routine stop turned into a documented incident with 2 agencies attached to it. Internal Affairs locked down his body cam, cruiser GPS, and dispatch audio. The plaza cameras got preserved too. Witnesses handed over videos. Kessler tried to write a report that made it sound like verification, but the footage showed the real sequence. He escalated first, dismissed valid credentials, then threatened detention anyway. Secret Service leadership contacted the department through formal channels. That raised the heat instantly. Command staff, the city attorney, and supervisors got involved. Kessler was placed on administrative leave while the review moved fast, because this wasn't a messy case, it was clean evidence. Within weeks, the department fired him. Short statement, no long explanations. The clips had already spread online, and the public reaction was blunt. People weren't surprised by the aggression. They were surprised to see consequences happen quickly. The city updated procedures for interagency contacts and reemphasized detention standards and de-escalation, mostly to prevent another officer from trying the same stunt on camera. Malik didn't chase attention. He documented everything, made sure evidence stayed preserved, and kept working. His win wasn't loud. It was official. It was on record. If you were in Malik's position, would you have stayed that calm? Or would you snap back and given the officer the excuse he wanted? Drop your take in the comments. And subscribe for more stories where power trips meet consequences.
Hold up, you got ID on you and proof you're a U.S. citizen.
I've got ID. What's the legal basis for a citizenship demand in the parking lot?
Here I ask questions, not you. Are you a citizen?
Yes, I'm the county sheriff. You're gonna regret it real quick.
The ICE agent stepped into Sheriff Darius Whitaker's space beside the SUV and treated the parking lot like his personal checkpoint. Citizenship proof, right now. No reason given that made sense. No clear allegation, just pressure. Whitaker didn't rush to satisfy him. He kept his hands visible and asked for the legal basis. He also asked whether he was being detained or free to leave. The agent ignored the question and repeated the demand. Whitaker handed over his driver's license and then his sheriff credentials, the kind of thing that ends misunderstandings fast. It didn't end anything. The agent looked at the credentials, dismissed them, and kept pushing like the only acceptable outcome was Whitaker scrambling to prove himself. A phone went up from a few cars away. Another person slowed near the storefront and watched. That's the moment you could tell this wasn't about law. It was about control. Quick pause. Where are you watching from? Country or state? Drop it in the comments. And if you watch these stories because you're tired of authority getting used like a weapon, hit like and subscribe. This one turns into a real accountability problem. Now rewind. Midday traffic filled that plaza lot like any other day. Coffee shop line, pharmacy pickups, people moving in short bursts, then disappearing back into cars. Cameras sat on corners of the buildings, pointed at entrances, covering most of the lanes without anyone thinking about it. Whitaker had come in off duty, plain clothes, no marked unit, no entourage, just errands. He parked, stepped out, and stayed near his vehicle for a minute while checking something on his phone. Nothing about his behavior suggested danger. No shouting, no confrontation, no looming around other cars. Agent Grant Heller entered from the far side on foot, not responding to a call, not finishing a stop. He walked with a locked-in posture that said he'd already decided what this was. He didn't circle, he didn't observe. He went straight at Whitaker. A normal officer starts with questions. Heller started with authority. He framed the contact as an immigration check immediately. He acted like he had the right to demand citizenship proof just because he felt like it. That's where the constitutional line showed up fast. In public, in a parking lot, the government doesn't get to treat people like paperwork dispensers without a lawful basis. Whitaker knew that. He also knew something else. When someone tries to run you over with authority, the story gets rewritten later, unless you lock down the facts in real time. So he did what seasoned law enforcement does when something feels off. He controlled his tone. He controlled his movements. He forced the encounter into clear categories. Whitaker asked for the legal basis. He asked whether he was being detained. He kept his voice even, like he was speaking for a recording, because he assumed there was one. He wasn't wrong. Heller refused to answer cleanly. He stayed vague while acting like compliance was mandatory. That's a common dodge. Keep it fuzzy so you can claim later it was consensual even while you box someone in. Whitaker didn't accept fuzz. He provided identification first. Then he added his sheriff credentials. It was an easy off-ramp. Any competent agent could have verified it through standard channels in minutes. Dispatch, database, supervisor call. Pick one. Heller chose none of them. Instead, he treated the credentials like they didn't count. That told everyone watching what mattered to him. Verification wasn't the goal. Dominance was. A bystander, Jasmine Patel, started recording early. She didn't announce it. She didn't argue with anyone. She just held the phone steady. That kind of footage becomes a problem for people who like to improvise their facts later. Whitaker noticed the phone and adjusted without making a show of it. He kept his hands in view of both the bystander camera and any plaza cameras. He didn't reach into the SUV. He didn't step toward the agent. He didn't give Heller an excuse to describe threatening movements in a report. Heller kept escalating anyway. His voice stayed sharp. His language shifted from questions to commands. He repeated the citizenship demand like repetition could create legal authority. He started acting like Whitaker's calm questions were attitude. That's the chess game right there. Heller tried to reframe professionalism as defiance. If he could label Whitaker uncooperative, he could justify pushing harder. Whitaker didn't bite. He kept the focus on standards. Reasonable suspicion requires specific facts, not a vibe. Detention needs a lawful basis, not an ego. Those rules apply even when the person pushing the contact wears a badge. Heller acted like those rules didn't apply to him. People nearby picked up on the shift. A couple of heads turned. A short pause in foot traffic. That low-level attention you get when something feels wrong, but nobody wants to be the next target. And here's the piece that makes the whole thing hit harder. Whitaker wasn't a random civilian getting bullied by a federal agent. He was the county sheriff, elected, public-facing. The type of person Heller should have recognized the second credentials appeared. Heller didn't miss it, he dismissed it. That choice matters, because it turned this from a possible misunderstanding into something else. A federal agent deciding that a black man's status didn't matter, unless he personally felt satisfied. Whitaker offered the cleanest solution again. Verify through normal channels. Confirm the credentials. End it like professionals. Heller refused again. His body position shifted closer to the driver's side area, narrowing Whitaker's movement. Subtle to some people, obvious to anyone trained. It's how you start turning a conversation into a detention without saying the word. Whitaker recognized the line getting crossed and responded the way you want a top law enforcement official to respond. Calm, specific, no drama. He made it clear he would cooperate with lawful verification. He made it clear he wasn't consenting to random demands that had no legal foundation. Heller didn't back down. He leaned in harder like he needed Whitaker to comply just to validate the approach. Heller didn't verify a thing. No dispatch call, no quick database check, nothing that would create an objective record. Instead, he tried to force the moment forward with commands. He kept circling back to citizenship proof and acting like Whitaker owed it to him, right there in the open, in front of strangers. Whitaker held his ground without making it a scene. He asked again if he was being detained. He asked again what specific facts justified the demand. He pointed to the credentials already in the agent's hands and pushed the obvious fix. Verify through standard channels. Heller avoided every clean answer. He kept talking like the authority itself was the reason. Body position changed next. Heller edged into the space by the driver's side area, close enough that Whitaker couldn't just step away without bumping him. That's how a conversation becomes a detention without anyone saying it out loud. Jasmine Patel's phone stayed up. Steady recording, no commentary. That's the kind of witness officers hate, because it doesn't get distracted and it doesn't get emotional. Heller started giving step-by-step compliance instructions that didn't match a voluntary contact. Hands placement, where to stand, what to produce. He tried to make Whitaker perform submission so the scene would look justified from a distance. Whitaker didn't argue every instruction. He stayed focused on the legal threshold. Detention needed reasonable suspicion. Reasonable suspicion needed articulable facts. Heller still hadn't offered one. At that point, Heller made it explicit in everything but words. Whitaker wasn't free to leave. The agent's posture, the blocking angle, the repeated commands. Same message. Whitaker warned him calmly that he was crossing into an unlawful detention. He told Heller he would cooperate with verification. He would not cooperate with a made-up checkpoint. That's when Heller reached for him, not to guide him away from traffic, not to protect anyone. The grip went to control. A wrist grab first, then a pull, like he wanted Whitaker repositioned for restraint. Whitaker didn't swing, he didn't jerk away. He tightened his arms, kept his hands visible, and made sure the bystanders could see he wasn't resisting. Smart move. Officers who escalate like this love to write resistance into the report later. Heller escalated anyway. He talked over Whitaker's attempts to explain. He dismissed the sheriff credentials again, framing them as irrelevant. In that moment, he made his real position obvious. Whitaker's identity didn't matter because Heller didn't want it to matter. Then came the slip that changed the whole tone. Heller justified his suspicion by leaning on how Whitaker looked and how he didn't match what a sheriff should be. He didn't use a slur. He didn't need one. The bias sat in the logic. Appearance first, facts later, verification never. You could feel the crowd react. A couple people moved closer without realizing they were doing it. Someone else backed away like they didn't want trouble. Jasmine adjusted her framing to capture hands and faces at the same time. Heller pulled out cuffs. Whitaker stayed controlled. He repeated that he wasn't resisting and that Heller had no lawful basis to restrain him. He also made sure to say clearly that he was the elected sheriff and that verification could happen in minutes if Heller would just do his job. Heller cuffed him anyway. That sound carried. Metal clicking in a public parking lot. Phones caught it. Security cameras likely caught it. Heller had turned a baseless demand into a physical seizure. With Whitaker restrained, Heller tried to take ownership of the narrative. He rattled through vague reasons, identity uncertainty, behavior, the refusal to produce what Heller wanted. None of it tied to a specific crime. The explanations kept shifting, which is always a bad sign. Consistent facts don't need constant rewriting. Whitaker didn't bargain, he didn't plead. He kept asking for the lawful basis and kept requesting verification through dispatch. He treated it like a procedural failure that was getting documented in real time, because that's exactly what it was. Then county backup arrived. Deputy Lena Park pulled into the lot after a call came in about a federal agent detaining someone. She stepped out, saw the crowd, saw the cuffs, and moved in fast enough to take control without escalating. Recognition hit her the moment she got close. That was her sheriff in restraints. Park didn't waste time debating feelings. She demanded the reason for the detention. She demanded the basis. She demanded Heller's identification and supervisor contact. Direct, professional, no room for performance. Heller tried to hold the scene. He attempted to keep talking past her, like the sheriff being cuffed was still just a subject in his operation. Park bypassed him and verified Whitaker through dispatch immediately. Speaker on. Clear enough for anyone nearby to hear. The confirmation came back fast because it wasn't complicated. Elected sheriff. Active? Known. Seconds of verification wiped out Heller's entire justification. Heller's posture changed right there. Less command voice, more damage control. He moved to remove the cuffs. Whitaker didn't gloat. He didn't raise his voice. He rolled his wrists once and looked at Heller like he was looking at a report that didn't match the evidence. Park told Whitaker to step back, breathe, and let her handle the immediate scene. Whitaker did, then started doing what experienced leaders do when something goes sideways, securing the record. He asked for the agent's full identifying information and supervisor contact again, this time with a witness and multiple recordings running. He told Park to request the plaza camera footage. He told her to document the bystander video contact info. He reminded her to capture timestamps and where each person stood. Heller tried to justify it one more time. He implied Whitaker's refusal to provide citizenship proof forced the escalation. He implied the credentials didn't resolve the immigration concern. He tried to make it sound like his hands were tied. Nobody bought it. Verification had taken seconds. The only reason it hadn't happened earlier was because Heller refused to do it. Whitaker made it clear he wasn't letting this get buried as a misunderstanding. He didn't threaten. He didn't rant. He stated what was going to happen next. Formal complaints, preservation requests, and a full review of the detention. Heller walked away with his authority intact on paper, but his credibility cracked in public. Cameras don't care about rank, and Whitaker didn't treat it like a parking lot argument anymore. He treated it like a civil rights violation that just handed him evidence. Whitaker didn't treat it like a bad interaction that ended when the cuffs came off. He treated it like a violation that only mattered if the record stayed intact. Deputy Park took names and noted positions. Jasmine Patel got asked for her contact info and the original file. Plaza businesses got hit with immediate requests to preserve camera footage before it auto-deleted. Time mattered. Some systems overwrite in days. Back at the sheriff's office, Whitaker did something most people can't do after something like that. He stayed methodical. He pulled the county dispatch log showing how fast verification happened once someone actually made the call. He documented the timeline while it was still fresh. He wrote down the agent's vehicle info, the sequence of commands, and every point where verification was offered and refused. The next piece was control of evidence. A preservation letter went out that same day through counsel, not a friendly email. A formal notice telling the federal agency to retain body-worn footage, radio traffic, CAD notes, and any internal messages tied to the incident. Another one went to the plaza property manager for all relevant camera angles, receipts, dates, specific time windows. Then came the predictable part. ICE management didn't open with accountability. They opened with tone management. A supervisor called and framed it like a misunderstanding that could be handled professionally if everyone stayed calm and kept it quiet. The message wasn't hard to read. They wanted this contained. Whitaker didn't take the off-ramp. He asked for the incident report number, the agent's full identifying info, and confirmation that all recordings were preserved. He also asked whether the agent had contacted any verification channel at any point before putting hands on him. The supervisor didn't give a clean answer. Meanwhile, Jasmine's video didn't sit in a folder for long. Somebody shared it. Maybe her. Maybe someone who got it from her. Either way, it hit local feeds first, then jumped to bigger pages because the situation was simple to understand. A federal agent demanded citizenship proof from a black man in a parking lot, ignored credentials, and escalated to cuffs. Public reaction came fast, not just outrage, recognition. People had their own stories and didn't need a lecture to connect the dots. Local reporters called the sheriff's office for comment. Whitaker didn't hide. He kept it tight. He confirmed the basics, confirmed the existence of video, and confirmed that his office was preserving evidence and pursuing review. That's when the agency tried to build a narrative. Heller's initial paperwork painted the contact like a routine check with safety concerns. It leaned on vague language, behavior, noncompliance, unable to verify identity. The usual. The problem was the timeline it didn't support it. Video showed Whitaker provided ID and credentials early. Dispatch logs showed verification happened in seconds once Park called. The agent hadn't used the obvious channels before escalating. Those facts sat there like a brick. Whitaker's attorney, Aisha Monroe, built the case the way these cases have to be built, not by arguing feelings, by pinning down contradictions. She pulled the exact timestamps from the bystander video. She matched them to the dispatch verification time. She requested plaza camera footage to cover what the phone camera didn't. She demanded any government recordings and communications tied to the encounter. She logged every delay. ICE didn't hand everything over quickly. That also wasn't surprising. Requests got slow-walked. Responses came in pieces. Some items got flagged as unavailable or under review. Standard friction. Monroe didn't get stuck in that lane. She filed formal complaints through multiple channels at once. Civil rights complaint, oversight complaint, internal review request. Each one created a paper trail that couldn't be brushed off with a phone call. Then the lawsuit got drafted. The core wasn't complicated. Unreasonable seizure, detention without reasonable suspicion, restraint without probable cause, racially driven suspicion dressed up as immigration enforcement. The demand for citizenship proof became central because it showed what the encounter was from the first seconds. Whitaker also made a strategic choice. He didn't frame it as, "They embarrassed me." He framed it as, "They'll do this to anyone," and it happened to someone with training, resources, and evidence. That moved the story out of ego and into rights. More witnesses came forward after the clip spread. A man near the pharmacy entrance said he saw the grab and the cuffs. A store employee confirmed the plaza had cameras covering that lane. Another bystander mentioned hearing the agent dismiss the credentials. Small pieces, but they stacked. Pressure grew inside the county, too. Some officials wanted it quiet because they didn't want tension with federal partners. Whitaker refused that angle. He'd spent years preaching documentation and lawful thresholds. If he folded now, everything he'd enforced on his own deputies would look fake. So he stayed consistent. Monroe filed in federal court once the evidence package was strong enough to box the agency in. Not a vague complaint, a timeline-driven one. Video references, dispatch references, verification references, specific actions tied to specific constitutional limits. And that's when things shifted behind the scenes. Because once it's in court, the game changes. Depositions get scheduled, records get compelled. People have to answer under oath. Reports can't hide behind vague words when a video shows the opposite. Whitaker didn't need revenge. He needed accountability that would survive excuses. Once the lawsuit landed, nobody could hide behind vague wording anymore. Monroe requested everything: the agent's reports, internal emails, radio traffic, any video, any notes about suspicion, and any policy the agent claimed to rely on. Then came depositions. Heller's story didn't hold up under structured questions. His reasons kept shifting. One minute it was identity. Next it was behavior. Then it was safety. The record didn't match any of it. Whitaker had provided ID and credentials early. Verification could have happened immediately. It didn't, because Heller refused to do it until Deputy Park forced it. That refusal became the center of gravity. Monroe didn't argue vibes. She argued thresholds. If the agent claimed reasonable suspicion, she demanded the specific facts. If the agent implied consent, she pointed to the blocking posture and commands. If the agency tried to sell it as a quick check, she walked the timeline second by second and showed how it escalated without a lawful anchor. Video helped, but the boring stuff hurt even more. Dispatch logs, timestamps, the gap between when verification was offered and when it actually happened. All of it told the same story. This was preventable, and the agent chose escalation anyway. ICE tried to narrow the case. They floated the usual moves: qualified immunity arguments, technical defenses, attempts to frame it as a misunderstanding with an officer who couldn't confirm identity. Monroe kept dragging it back to one point. The agent didn't try to confirm. He skipped the simplest verification steps and moved straight into control. That's not enforcement. That's a power play. Pressure built on the agency for a second reason: credibility. If this reached a jury, the visuals were brutal. A black man in cuffs in a public parking lot after presenting law enforcement credentials. A quick dispatch confirmation that proved how unnecessary it was. A written narrative that didn't line up with what the cameras captured. Jurors don't need legal training to understand that. Behind the scenes, settlement talks started getting serious. Whitaker didn't come in asking for a symbolic win. He came in with evidence and a standard. Accountability has to sting, or it teaches nothing. He also had leverage most plaintiffs don't. He knew policy. He knew procedure. He knew how to explain it in plain English without sounding like he was performing. That made him dangerous to cross-examine. The agency also had a bigger headache. This wasn't just about one agent. If discovery showed patterns, training gaps, or loose supervision, the case could expand. Nobody wanted that on the record. So they paid. The number landed at $12 million. That settlement didn't happen because someone felt bad. It happened because the agency didn't want a courtroom replay of an unlawful detention built on appearance and ego. The money reflected the constitutional violations, the restraint without probable cause, and the fact that the agent ignored verification options that would have ended the contact cleanly. Then came the non-money part, the part agencies hate even more. New protocols tightened how agents could initiate public space contacts without a clear immigration-related basis. Verification requirements became explicit. Supervisory involvement triggers got added for any detention that wasn't grounded in a defined operation. Documentation rules got stricter because loose narratives were what created the problem in the first place. Training shifted too, not the performative kind. Scenario-based work focused on thresholds and bias cues. The key lesson was simple. If an encounter starts with "prove you belong" instead of articulable facts, it's already off track. Heller didn't walk away unmarked. The agency handled discipline and assignment changes internally, but the career hit showed up anyway. Cases follow agents. Depositions follow agents. Supervisors remember who brought a $12 million problem into their lap. Whitaker's side changed as well. He didn't treat the settlement like a trophy. He treated it like a warning label. He built a county training block around the incident, using it to drill one message into his deputies. If you can't clearly state the legal basis, you don't escalate. If verification is available, you verify. If your suspicion is really just a feeling, you stop and reset. He also gave credit where it belonged. Deputy Park's quick verification mattered. Jasmine Patel's recording mattered. The plaza cameras mattered. Oversight didn't arrive by magic. People created it by documenting. That's the part viewers should sit with. If this could happen to a sheriff in broad daylight, it can happen to anyone. The difference was that Whitaker knew how to freeze the moment into a record. He had witnesses. He had procedure on his side. He had the patience to play the long game instead of trying to win in the parking lot. So here's the question for you. If you were standing there watching, would you record like Jasmine did? Or would you keep walking because it feels safer? Drop your answer in the comments. Share this story with someone who thinks rights only matter when you're loud. And if you want more real, grounded stories where accountability actually lands, hit subscribe.